The TWC has advice for your business about references and background checks. My name is Nina, and I'm about to get in your business. If you would like to know more about the topics listed below, click that subscribe button. Smash that notification bell. I upload new videos on Thursdays. On the Texas Workforce Commission website, there is all kinds of useful information. In my new series, Reading the TWC Website, I troll the website of the Texas Workforce Commission, grab interesting information, and I read it to you. I'm going to read directly from the TWC website to let you know what they say about references and background checks. Even though this information is found on the Texas Workforce Commission's website, it's good information for any business, no matter where your company resides. Listen to this video while you're working on a computer or doing other things. The average telephone reference call will not yield much usable information. Employers are concerned about being sued for giving unfavorable references. Case in point, a terminated employee suspected former employer was bad-mouthing him behind the scenes. Ex-employee hired private investigator to pose as a prospective new employer and call the former employer for a reference. Investigator tape recorded the employer making scurrilous and unprovable allegations about the ex-employee's character and honesty. Jury decided that was defamation and awarded almost $2 million in total damages to the former employee. Note, under Texas law, it is legal for a person to tape record a conversation without the knowledge or consent of others, as long as the person doing the recording is participating in the conversation. All applicants should sign a waiver and release of liability from clearly authorizing prior employers to release any requested information to your company and relieving both the prior employers and your company of all liability in connection with the release and use of the information. Note, this is not on the TWC website. I highly recommend that all requests for this type of information be sent via email. That way, your company will have a record of what information was submitted. Back to the website. Whatever information an employee releases in connection with a job reference should be factual, in good faith, and non-inflammatory. Under the Texas Labor Code, a truthful written job reference cannot be the basis for a defamation lawsuit. Similarly, it would be a good idea to restrict the release of information to whatever was requested unless there is a compelling need to do so. Try not to volunteer additional things that are not connected to the information requested by the prospective new employer. Texas law gives employers important protections against defamation lawsuits based upon job references, as long as the employer does not knowingly report false information. Still, employers should try to report only what can be documented. Employers have the right to do criminal background checks themselves using government-maintained databases, but most employers hire a service to do that. Be careful, since the Fair Credit Reporting Act requires an employer to give written notice that a credit or background check will be done and to get written authorization from an applicant to do the check if an outside private sector agency or search engine will be used. The notice and the authorization can be on the same form. In addition, if the applicant is turned down, the employer must tell the applicant why, give the applicant a copy of the report, and let them know the name and address of the service that furnished the information. In-home security and residential delivery companies must perform a complete history background check through DPS or private vendor on any employees or associates sent by the companies into customers' homes. And that includes attached garages or construction areas next to homes. or else confirm that the persons sent into the homes are licensed by an occupational licensing agency that conducted such a criminal history check before issuing the license. The records must show that during the past 20 years for a felony and the past 10 years for a Class A or B misdemeanor, the person has not been convicted of or sentenced to deferred adjudication for an offense against a person or family, an offense against a property or public indecency. A check done in compliance with these requirements entitles the person's employer to a rebuttal presumption that the employer did not act negligibly in hiring the person. Recommended: do such checks on anyone who will be going into a person's home, garage, yards, driveways, or any other area where the employee could come into contact with people at their homes. With respect to applicants younger than 18, if possible, secure written permission from the child's parent or guardian to conduct background or drug tests. Unless a law requires such a question, do not ask about arrests, since the EEOC and the courts consider that to have a disparate impact on minorities. A company can ask about convictions and pleas of guilty or no contest. If an EEOC claim is filed, the employer must be prepared to show how the criminal record was relevant to the job in question, i.e., the employer must be able to explain the job relatedness of the offense. Conducting a job relatedness inquiry involves treating each applicant as an individual. The employer must be able to articulate how it determined, with respect to an individual applicant, in light of the applicant's criminal history and concerning the job in question, that hiring the person would have involved an unreasonable risk of possible harm to people or property. In Texas, asking only about convictions will not turn up some forms of alternative sentencing. Under the law of deferred adjudication, if the person given such a sentence satisfies the terms of probation, no final conviction is entered on the record and the person can legally claim never to have been convicted of that offense. However, they would have pled guilty or no contest to the charge. Such a plea is necessary in order to qualify for deferred adjudication. So if it is necessary, job related, to know about convictions and guilty or no contest pleas, the question would have to be rephrased. Here's a sample question about criminal history. During the past blah 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 years, have you been convicted of or have you pled guilty or no contest to a felony offense? If yes, please explain in the space below. Answering yes to this question will not automatically bar you from employment unless law requires such action. Try to consider only criminal history that is recent enough to be relevant, given the nature of a particular offense, the nature of the job, and the corresponding level of risk or harm. The remoteness of an offense is a factor in the job relatedness determination noted above. To minimize the risk of an EEOC claim and to be as fair as possible, try to keep the following in mind. Prior involvement with the criminal justice system should never be used as a blanket disqualifier unless a statute or relevant agency regulation requires such a result. Hiring decisions should be based upon individual characteristics instead of stereotypes. The best advice for employers in this regard is really to follow the EEOC guidelines on job relatedness determinations as explained in this topic. In general, there is no substitute for treating people as individuals and, to the extent possible, for taking the time to know about a person than just what official records might show. If an exclusion based on criminal conduct would have a disparate impact on minorities, EEOC expects the employer to develop a targeted screen that takes into account the nature and gravity of the crime, how much time has passed since the crime occurred, and the specific functions of the job in question. Any person excluded by such criteria would have an opportunity for an individualized assessment to determine whether the criteria as applied are job-related and consistent with business necessity. The individualized assessment would involve notice to the individual that the criminal record may result in him or her not being hired, an opportunity for that applicant to explain why the exclusion should not be applied under his or her particular circumstances, and consideration by the employer of whether the individual's new information justifies an exemption to the exclusion and show that the policy is not job-related and consistent with business necessity in the applicant's specific situation. Be cautious concerning offenses that occurred too far in the past. EEOC's policy statement issued on February 4th, 1987 on the use of conviction records in employment decisions cite a 1977 court case as authority for requiring employers to take into account the nature and gravity of the offense or offenses, the time that has passed since the conviction and or completion of sentencing, and the nature of the job for which the applicant has applied. Never ask an applicant to take a polygraph exam unless your organization is statutorily required to do so. That would be a violation of the Employee Polygraph Protection Act of 1988, a federal law. An employer may require an applicant to be responsible for submission of official records, transcripts, certifications, and licenses. Very important. In order to position your company as well as possible against potential negligent hiring claims, document your efforts to verify the work history and other background information given by the applicant. Flip side, negligent referrals. Do not ever give false or misleading references, even if you think you are insulating yourself from defamation claim or doing the ex-employee a favor. A Texas employer got hit with a large damage award after giving a false reference on a former employee who had been fired for misconduct. If you have knowledge that an ex-employee has violent tendencies, it is best to be truthful and factual in job references. Report only what you can document or prove with first-hand witnesses. Above all, do not falsely report that an employee who is known to have been violent or threatening was a good employee who followed all the rules. HR best practices. If possible, do not ask about criminal history until the tentative offer of employment has been made. That will lower your risk of discrimination based on criminal history for the majority of unsuccessful applicants. A number of states and some individual cities have enacted the so-called ban the box legislation, or ordinances under which an employer cannot ask about criminal history until the time that the company offers the job on a tentative basis. As of 2016, Texas has no such statute. Consult with qualified employment law counsel regarding the latest requirements in your company's area or areas of operation. Do the research to find out if such an ordinance is in the city where your company resides. My next TWC video will review what's on their website about interviews, pre-employment tests, exams, and tips on deciding who is the best candidate for the job. Thanks for watching.